On December 15, 2018, Winston Wesley Knowles, an independent investigative journalist, was positioned at a public street corner in Royce City, Texas. During his demonstration, he held up several signs, a few of which included explicit language. Approximately 15 minutes into his activity, Sergeant Nick Dial of the Royce City Police Department, accompanied by 2 other officers, including Officer Keith Short, arrived on the scene responding to citizen complaints. In the course of the investigation, Sergeant Dial physically struck the placards from Mr. Knowles' hands, effecting a warrantless seizure of property and a prior restraint on his speech. Mr. Knowles was subsequently taken into custody without probable cause, facing state charges of disorderly conduct and resisting arrest. Ultimately, the prosecutor dropped all charges against Mr. Knowles. On December 18, 2020, Knowles initiated a pro-SE civil rights lawsuit in the U.S. District Court for the Northern District of Texas. While Mr. Knowles originally managed the litigation himself, he later retained the services of attorney Daniel Alexander. On May 11, 2022, Mr. Alexander deposed Dr. Kelly Stone, who was an expert witness for the defense.
Could you tell me about your experience as a peace officer instructor? What did that involve?
I taught at the Collin County Law Enforcement Academy, subjects in arrest, search, and seizure, use of force, a broad range over 10 years with the Collin County Law Enforcement Academy. And then for 14 years, I was an adjunct instructor at University of Texas at Dallas and taught various courses in Homeland Security, leadership and law enforcement, different courses along that line.
You mentioned teaching about arrests. Did you teach classes about how to arrest people?
I taught classes in use of oleoresin capsicum, but not the actual physical arrest of a person, but the facts surrounding the arrest and different aspects of an arrest, yes.
Did you ever teach about the right of a person to speak freely?
You know, I can't think specifically, but I would say that would have been part of my conversation or instruction.
I'd like to introduce Exhibit 3 as the guidance from the International Association of Chiefs of Police. It's a presentation that's titled Arrests and Investigatory Stops. So here it guides that when making an arrest, no arrest shall be made at a time or in a manner contrary to any express limitations included in a warrant or in a manner or at a time or place prohibited by relevant court decisions. If the relevant court decisions say that a person's speech is protected by the First Amendment, is it reasonable to arrest that person for that speech?
Yeah. Yes, there are times that it would be reasonable to arrest in a matter of issue of speech.
Are you saying that it's reasonable to arrest a person for protected speech?
Not for protected speech, but outside the guidelines for disorderly conduct. Fighting words is not protected speech, for example.
Do you think that the United States Supreme Court is an authoritative source of the law in this country?
I do.
What about the Texas Supreme Court?
I do.
What about the Texas Courts of Appeals?
Yes.
Are these courts authorities on individuals' rights in this country?
Yes.
Is it reasonable for a police officer to violate the rights of an individual?
No.
So do you agree that if the courts say that an action violates an individual's constitutional rights, then that action is unreasonable?
Objection, form.
That action is what? I'm sorry.
I'm asking you if the courts have said that an action is in violation of an individual's constitutional rights. Is it reasonable for an officer to take that action?
Well, I would say that, all of those depend on the circumstances, but if there is a specific ruling about language, I would say it would be unreasonable for an officer to do that if there are no other variables associated with the action.
Are you saying that it's reasonable for an officer to sometimes arrest a person in violation of their constitutional rights?
No, I'm certainly not.
So it's never all right for an officer to arrest a person in violation of their constitutional rights.
I would agree with that.
Are you familiar with what the United States Supreme Court has said about the acceptable restrictions that a state can put on a person's First Amendment rights to speech?
I haven't reviewed that. I'm not familiar with the latest ruling.
Well, there's a case from 1971 called Cohen v. California that says that states can ban fighting words. And that's words that are inherently likely to provoke a violent reaction. Are you familiar with that case?
Objection form.
I'm not actually familiar with the language, but I have looked at previous Supreme Court rulings about fighting words. Yes.
This case was from 1971. Are you familiar with it?
No.
If the law says that speech is protected unless it's likely to provoke a violent reaction, is it reasonable to arrest that person for that speech?
Can you state the question one more time, please?
My apologies. If the law says that speech is protected unless it's likely to provoke a violent reaction, is it reasonable to arrest a person if their speech didn't provoke a violent reaction?
Objection form.
Yeah, I would say if it's yes, I would agree with that.
So speech needs to provoke a violent reaction to be fighting words. Do you agree?
I don't think, no, I would disagree with that. It's the potential, well, it doesn't have to provoke. It's the potential to provoke, not that provocation was immediate, but circumstances could rise to that level.
Okay, there's another case from 1989, called Texas v. Johnson. Are you familiar with that case?
No, sir, I'm not.
It says that the government may not prohibit the verbal or nonverbal expression of an idea merely because the society finds the idea offensive or disagreeable. Do you think it's reasonable to arrest a person solely because a member of society finds that speech offensive?
Objection form.
Not in every circumstance, no.
Do you think it's reasonable in some circumstances to arrest a person for their speech solely because a member of that society thought that speech was offensive?
Objection form.
Okay, ask the question one more time so I can focus on it a little better.
I'll ask you a different way. If I go outside and scream fuck, and somebody calls the police and says they were offended by that statement, should I be arrested?
Objection form.
No, especially if you stepped outside of your home and yelled that, certainly not.
So you're saying that if I'm outside my home and I shout a curse word, I should not be arrested, even if somebody found it offensive?
You're at your residence. I would say no to that.
Mr. Alexander questions Dr. Stone regarding the Roy City Police Department's policies on protected speech and the First Amendment, and the defense attorney Joe Tooley repeatedly objects to the form of the questions. Under Rule 199.5 of the Texas Rules of Civil Procedure, oral objections during a deposition are strictly limited to objections that a question is leading or that its form is improper. An objection to form addresses defects in how a question is posed, such as when a question is vague, confusing, or calls for a legal conclusion from a witness. Despite these objections, Dr. Stone is generally required required to answer the questions regarding First Amendment and fighting words, as the deposition officer does not rule on the objections at the moment. They are recorded for later determination by the court. Mr. Tooley's objections to form here suggest a disagreement with how Mr. Alexander frames the distinction between offensive speech and fighting words. Under the First Amendment, speech that is critical of the government is protected unless it is likely to incite immediate physical violence. Mr. Alexander also uses the Guidance on Arrests Policies documents to argue that the officer's interference with Mr. Knowles' signs was a departure from established training. Because the defense attorney's objections were primarily directed at the form of the questions, the testimony provided by Dr. Stone regarding these police standards remains part of the record, provided the court does not later sustain those objections and strike the testimony.
Did you ask Short why he moved the tripod?
I either asked him or he told me, yes.
And what did he say?
He said that that he thought that the suspect was going to be arrested, and that there was an area by the tripod that was wet and muddy, and he moved it to the side where he wouldn't step in the mud if he needed to assist.
And so you're saying that it was reasonable for him to move that tripod to make space for him to assist?
That's what he said, yes.
And
And I think that's reasonable.
would it have been reasonable for him to simply step around the tripod and get closer?
Well, if it wasn't for the mud, I guess it would have was his point. He moved it to avoid stepping in the mud if he needed to assist.
But couldn't he have just gotten closer to the potential arrest without moving the tripod?
Objection. Form.
I guess he possibly could, but he couldn't have stayed in the same position that he was in, observing the suspect.
Did you ask Short if he knew what was on the tripod?
He told me that he learned later that it was a cell phone on the tripod.
But did you ask him when you talked to him if he knew what was on it during the arrest?
I believe he just told me that he thought that he saw it was a cell phone. He did, or that he moved it at the time. He didn't know it was a cell phone, but I'm trying to recall. He wasn't sure what the device, what it was, but he was just, I think he told me he thought it was a light on a tripod.
Did he tell you why he thought that? Having some technical.
Well, it was on top of a yellow stand, which is something you would see a light on, like that, a yellow tripod.
Do you think it was reasonable that he thought it might be a light?
I don't know what, I don't know. But yeah, I would say if you're there and you're watching a person and you're there backing someone up, you're more focused on that than you are an object that's potentially in your way.
Would you ever expect a person who wasn't shooting a video to have a light on them outside during the day?
I don't have any idea.
The report reads here that after looking closer at the device, he noticed it had a black case attached to it. Did you follow up with him about what he thought that black case might mean?
I did, because he later on he told me that he learned, and I think it's somewhere in my report that that he didn't learn till later that it was a phone, and that he didn't see, he learned later that it was a phone. And the rest of it's down at the bottom there, that if he was, Knowles was videoing, recorded by a patrol vehicle, he knew that Mr. Knowles was being video recorded by patrol vehicles, dashboard cameras at the scene, which is their policy. And that that the footage is always properly stored for recovery.
Right. But I'm asking you about Short's understanding of the object that was on the tripod. It says, after looking at the device, he noticed it had a black case attached to it. Did you ask him if that black case changed his opinion about what that might be?
I didn't ask him that question.
So are you saying that he told you that he noticed it had a black case attached to it and you asked no follow-up questions about that? Is that right?
Yeah, I think he thought it might be a phone, but he didn't think the phone that it was recording.
Did he tell you that he thought it might be a phone?
Let's see. I'm looking at my report. No, later on he said when I talked to him that it had been alleged that the device was a cell phone videoing location where Mr. Knowles was standing. Officer Short did not see any indication that the device was recording, but was aware that the contact with Mr. Knowles was being videoed and so forth.
Do you think it was reasonable that Short didn't try to figure out what was on that tripod?
Yeah, he's there backing up an officer and spending time on something that's remote. I think his attention should be on the officers and the suspect.
But do you agree that cameras are often on tripods?
I know they are from time to time, but it's not always what's on a tripod. But yeah.
So you don't associate tripods with cameras, is that what you're saying?
No. Not a yellow construction tripod. I don't. I'm not sure if the officer did, but that's
if Short had known that day that that was a camera on the tripod, would it have been reasonable to move it?
if it's getting his access to the suspect.
Even if it was a camera that was recording?
You know, it would always be better if he didn't move it, if he knew it was a camera recording. I don't think we should do that.
And why is that?
Well, because it's if they're recording something, they have a right to do that.
Mr. Alexander questions Dr. Stone relating to Officer Short moving Mr. Knowles' tripod. Dr. Stone defends Officer Short's decision to move the tripod by framing it as a routine act of scene management. However, this interference with the recording equipment directly implicates the First Amendment right to record law enforcement in public spaces. In the 2017 case of Turner versus Driver, the Fifth Circuit established that citizens have a right to film police officers performing their duties, subject only to reasonable time, place, and manner restrictions. By rotating the camera, Officer Short effectively terminated Mr. Knowles' ability to document the totality of the circumstances, an action that courts often view as a constitutional injury. Furthermore, Dr. Stone's reliance on officer discretion must be balanced against the standard of objective reasonableness found in Graham versus Connor. If the hazard cited by the officer was merely a pretext to silence a recording, the act moves beyond the scope of protected discretion and becomes a form of First Amendment retaliation. As illustrated in cases like Irizarry versus Ye, physical interference that disrupts a recording can be seen as an action intended to silence a person of ordinary firmness from exercising their constitutional rights.
Okay, I'd like to turn your attention back to your report. It lists here a series of materials that you reviewed in creating your opinions and conclusions in the report. I notice here that it doesn't say that you reviewed any actual laws. Is that right?
Objection form.
Well, I think I included language about I think I included language about disorderly conduct and resisting arrest. That's included in my report, isn't it?
Yes, you cite the language for Penal Code Section 42.01 and 38.03,
Yes.
but I'm asking you, did you review these statutes when preparing the opinions in your report?
Yes, I reviewed these statutes yes.
Did you review any other law in preparing your report?
Those two, and then not when preparing my report, but I did look at some different case laws.
Can you tell me what that case law was?
Well, the first one that I looked at was New Hampshire 1942 Supreme Court decision in the Chaplinsky and New Hampshire 315 U.S. 5568. I think there's another one. If you can bear with me a second, I'll see if I can.
Of course.
The other one is that I looked at was Duran versus Furr.
And you said earlier that the United States Supreme Court and the Texas courts establish what the law is. Is that right?
Objection form.
That they establish what the law is? No, I don't think that's correct. I didn't.
So are you saying that United States Supreme Court decisions are not the law?
Absolutely not. I said just the opposite.
Are United States Supreme Court's decisions the law in this country?
Yeah, they're through appeals, they set precedents in our laws in this country.
And that applies to the Texas courts as well?
Yes.
Do you think that an officer would know the law if he doesn't keep up with the court cases?
Well, most agencies provide updates, especially on legislation that's significant. So the agencies that I've worked at have, when Supreme Court has made decisions, has provided that information to the officers that were in law enforcement. And as far as I know, well, definitely in Collin County Sheriff's Office, the last 36 years of my career.
Is it unreasonable for an officer to be unaware of the law as established by the courts?
Well, I would say yes. When we're out there doing our job, that there's a level of unreasonableness of not knowing or taking the time to learn. But yes.
Would an officer know the law if he doesn't study court cases?
Only in the manner that I previously mentioned to you and explained, where agencies provide Supreme Court decisions to their officers for review.
Does an officer need to study court cases to know the law?
No.
But earlier you said that the courts establish the law in this country. Isn't that right?
Yes.
So if an officer doesn't know what those courts said, how can they know the law?
By the means that I explained to you a couple of times, and that's where an agency provides those decisions to the officers for their review and part of their training normally.
And do those materials include cases from before the officer became active?
Objection form.
Hopefully before they become active, they got it in the academy. But this is follow-up, my experience. The agency that I work for, they provided Supreme Court rulings that were significant to officers doing their job.
You're talking about new Supreme Court rulings, right?
Yes, I am.
So when an officer first becomes active, would that officer know the law if they'd not been trained in court decisions?
If they didn't have the training that I've already mentioned before, which would include Supreme Court decisions and things that affect their job, which is, I understand to be the standard So the ideal is that they get it in the academy, and after they get out of the academy, they get updates. And again, I'm not familiar with the updates for basic, intermediate, advanced, what they get. I'm not directly involved in that anymore. And
But if
because
an
I'm a master peace officer.
But if an officer did not keep up with court decisions after he became active, would he know the law?
The only way that they would know the law if they get the updates from their agency on updates from Supreme Court decisions.
But if they didn't read those updates, would they know the law?
Probably, I wouldn't assume that they would know the law, but normally they have to sign the document saying that they received it and read it. Is a normal practice in law enforcement agencies.
Mr. Alexander questions Dr. Stone if the officers are aware of the laws before the officers get out of the academy. Dr. Stone relied on the officers getting continuous updates after they got out of the academy. Under the Supreme Court's ruling in Cohen versus California, which established that the government cannot prohibit the display of expletives when the speech is not directed at a specific individual to incite violence. Furthermore, under the doctrine from Chaplinsky versus New Hampshire, the court clarified that speech is only criminalized if it involves personally provocative insults likely to cause an average person to respond with immediate violence. Mr. Alexander questions Dr. Stone about officers' conduct related to their knowledge of the law. Because Mr. Knowles' signs were not directed at any particular bystander, the analysis concludes that his conduct fell well within the bounds of protected speech. Consequently, the officers lacked the reasonable, articulable suspicion necessary to detain him or the probable cause to arrest him for disorderly conduct, which, according to Mr. Alexander, would be an indicator of the officer's lack of knowledge of the law. Under these circumstances, the subsequent charges for failure to identify and resisting arrest are legally unsustainable, as they were predicated on an initial constitutional violation.
You just recited the disorderly conduct statute. We can review it here in your report. And the language by its very utterance tends to incite an immediate breach of the peace. What does that mean to you?
Well, number one, it really is dependent on location. Earlier, we were having discussions about in your front yard, but just exactly what it says that it could rise to an occasion where there's violence, a riot, or other consequences.
What Winston Knowles said that day on his signs and anything he said verbally, that couldn't cause actual or threatened violence, could it?
Well, I think it could. He's standing beside the road. We're on a day where cars are passing by, stopping at a stop sign. So the answer to that is yes, it could.
Would it change your opinion if there were case law in Texas that a speaker needs to have more contact with the observer than one motorist passing by?
There's nothing prohibit a motorist from stopping. So he was 3 feet from the edge of the road.
If there was case law in Texas saying that it's not enough to say a curse word at a motorist passing by, would you agree that a subsequent arrest was unreasonable if that's what happened?
Objection, Thorne.
Yeah, I don't. Of course, here the issue is that once there's an arrest, there's a need for follow-up and done by the prosecution. So is normally what takes place in talking to witnesses and so forth. So I know in this case I still believe that a reasonable officer in Clark's shoes is the one actually that did the arrest would have arrested Mr. Knowles.
What did Mr. Knowles say that threatened violence?
Objection, Thorne.
Well, it's in the report. He turned to someone and stopped at a stop sign with their window rolled down and put his arms out to the side and said, "What the F?"
So you're saying that if somebody says what the F to somebody in a car with their window rolled down, that could threaten violence. Is that right?
Well, that with the signs and people calling in and complaining to the police department, stopping police officers where they were. Yes.
So you're saying that society's offense to the statements determines whether the conduct was disorderly. Is that right?
Objection, Thorne.
No.
But you just said that that a factor is whether people are complaining.
What I said is that there were numerous people stopping police officers and calling in and complaining.
And that was a factor in determining whether there was threatened violence. Is that right?
Yes, I think the potential is there for that.
And if Texas courts say that an immediate breach of the peace contemplates a face-to-face encounter, or at least something more than the impersonal, brief encounter of a passing motorist, would that change your opinion?
At this point, what I know and understand about the fighting words doctrine, that would not change my opinion.
So if I go outside and yell fuck at somebody that's driving by in a car with their window rolled down, and somebody calls the police to complain, should I be arrested?
No.
Why?
Objection, Thorne.
Going outside, you're providing a broad description and circumstances that I would just say no, based on the limited amount of that you shouldn't be arrested, the limited amount of information that you've given me.
If I stand on the same corner that Winston Knowles stood on the day that he was arrested, with the same amount of traffic, and I yell fuck at a passing motorist with their window rolled down, should I be arrested?
Objection, Thorne.
I'm not sure you should be arrested if that's all that was taking place.
What else needs to
That
happen?
person's probably, multiple people stopping and calling in the police and complaining about signs with vulgar language while they're driving down the road.
So the difference is that people complained. Is that right?
Well, I'd say that's part of it.
If I stand on that same corner on the same day that Winston Knowles was there, and I yell, fuck this country, fuck the draft, fuck everything, should I be arrested?
Objection, Thorne.
No one complains. No one is offended. Then you shouldn't be arrested.
What if one person complains?
One person complains. I think it's appropriate for the officer to contact that person and find out what's going on with the individual.
But not arrest
He has
them?
reasonable suspicion to contact that person.
Should that person be arrested?
Objection, Thorne.
I think it depends on what happens after he contacts that person.
What if nothing happens? What if nothing else happens?
Then
Objection, Thorne.
I would say if nothing else happens and they feel confident that he's not going to carry his conduct any further, then I wouldn't think that person would be arrested if that's all that happens.
So you're saying a person should be arrested because the police think that they're going to say curse words in the future?
Objection.
No, I didn't say that. What I said, if nothing else happens, refusing to identify themselves, to explain, talk to the officers, carrying it another level is a matter to consider as well too. And where it is a matter to consider.
Does a suspect have an obligation to identify themselves to officers?
Yes, when there's reasonable suspicion to stop and talk to an individual, they have to identify themselves.
Can a person be arrested if they don't identify themselves to an officer?
It would other circumstances, but if a person is uncooperative and committing an offense and fails to identify, that charge could be added, yes.
Is there a statute requiring an individual to identify themselves to police officers before an arrest?
No, not that I'm aware of.
But didn't you just say that a person can be arrested for not identifying themselves?
I don't think that's what I said. I think what I was saying is the totality of those circumstances and the individual not cooperating to even where an officer can determine what's going on with that individual. Their potential to cause more problems.
Does an individual have an obligation to identify themselves to police officers?
Yes, when they're being detained and interviewed and questioned, when there's reasonable suspicion. But if somebody's just walking down the street minding their own business, there's nothing that requires that they identify themselves unless there's reasonable suspicion to believe a crime has been committed.
So are you saying that if there's reasonable suspicion and an officer asks somebody to identify themselves, they are legally required to identify themselves?
Yes, the failure to ID.
Is that based on a state statute?
I hadn't filed that charge in a long time. I'm not certain about that.
Are there common law crimes in Texas?
No.
So logically, it must be based on a state statute, right?
Yeah, it must be based on the state statute, but I don't know the statute.
And have you reviewed that statute recently?
No, I haven't.
So just to be clear, you don't know the statute on
Failed ID
by yourself.
No, I don't.
Okay. But you do know these other statutes, right?
Objection.
Yeah. Yeah.
Mr. Alexander questions Dr. Stone about whether someone has the obligation to identify themselves to law enforcement when requested, and Dr. Stone wrongfully clarifies that a person has to identify themselves during an investigation. Under Texas Penal Code 38.02, a citizen is only legally required to provide their name, residence address, and date of birth after they have been lawfully arrested. Mr. Alexander argued that because the initial arrest for disorderly conduct lacked a valid legal basis, the subsequent demand for identification was an overreach of police authority. Mr. Alexander emphasized that for speech to be criminalized under Texas law, it must consist of personally abusive insults directed at a specific individual in a manner likely to provoke an immediate physical confrontation.
What is the factual basis for your assertion that Dial hit those signs to protect his officers and search for weapons?
Well, it asked to see the signs, and the individual, they had reasonable suspicion that a crime had been committed. Well, therefore, they had the justifications for search, and the signs were blocking the view. They're big enough that he could have a weapon in his waistband or anywhere else. So that's my basis for that opinion.
But you just said that he hit those signs to search for weapons, correct?
Well, what I was saying that was the purpose of getting the signs out of his hand would be my position on it.
How do you know that that was the purpose?
Well, when I interviewed him, he told me that he had knocked the signs away, or he was concerned about the person having a weapon.
So when you gathered information about this case and about the actions of Dial, you derived most of your facts from the phone call? Is that right?
No, not at all. Most of the facts that I got were from the audio and video that I watched for each one of them for an extended period of time.
You're saying that Dial told you that he hit those signs to search for weapons. Is that right?
I don't know whether it was inferred or we had a discussion about it. Anyhow, I believe that's the reason that he hit the signs.
Did he tell you that's the reason he hit the signs?
Oh, I did read it in his deposition that we just had gotten recently. He had mentioned that, so that's where I got that.
So he didn't tell you that when you talked to him?
No, I think that's where I got it, was reading it in the deposition.
Did you ask him when you talked to him why he hit the signs?
No, I didn't.
Did you think that was relevant to your opinion in your report?
No, I didn't.
You're saying that you didn't think that it was important to your opinion in this report whether Dial had a legal foundation for hitting those signs?
Not that I could see. I mean, we don't need a legal reason to knock a sign from somebody's hand. Well, I don't understand that question.
Do you need a legal reason to hit a sign?
No, other than to search. I mean, that's what he said was his intent.
And you're getting that from his deposition, is that right?
I did.
Not from the call with him?
I don't think I asked him about it in the call.
So would you agree that if he didn't say that in his deposition, then that's not the reason he hit the signs?
My understanding is that's why he hit the sign. So, but an officer can take whatever action they think is necessary to search or protect themselves or the others that are at that scene.
What you're saying is interesting because these depositions occurred after you wrote your report.
That's true. There's nothing in my report about it, just your questions.
During the exchange, Dr. Stone claimed that his understanding of why Sergeant Dial struck the signs out of Mr. Knowles' hands was derived from the officer's depositions. However, Mr. Alexander directly confronted him with the timeline, noting that Dr. Stone's expert report was authored well before those depositions actually occurred. This confrontation leverages the foundational mechanics of impeachment by contradiction under Federal Rule of Evidence 607. Furthermore, it exposes a severe compliance failure under Federal Rule of Civil Procedure 26, which strictly mandates that an expert report contain all data and facts the witness considered in forming their opinions. Because Dr. Stone's report was finalized prior to the depositions of both officers, its conclusions could not factually or legally have been based on their testimony, laying bare a glaring contradiction for the court. After the deposition concluded, the lawsuit proceeded through the discovery phase, and on April 15, 2023, it was resolved when both parties came to a settlement. According to Lackluster, Mr. Knowles agreed to settle for just below $25,000. This deposition highlights the power of effective cross-examination and the critical importance of credibility for any witness who gives his testimony, particularly an expert. Unlike a fact witness who testifies only to what they personally observed, an expert witness like Dr. Stone is permitted to offer professional opinions. The jury is asked to trust not just what the expert says, but the foundation of objective analysis and law enforcement experience upon which those opinions rest. Mr. Alexander's cross-examination demonstrates that undermining an expert witness on their objectivity and consistency can be just as effective as challenging the underlying technicalities of the testimony itself. By validating the aggressive, unannounced arrest as standard procedure, Dr. Stone inadvertently highlighted the severe costs of the department's actions, demonstrating how a citizen was subjected to an intrusive physical seizure that directly compromised the objective reasonableness standard guaranteed by the Fourth Amendment. An expert who appears willing to bend a department's explicit notification rules to justify a stealth, grab-first arrest invites the jury to question every other conclusion they present on the stand. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more cases breakdown.